Single.
What size is represented? List after 2 weeks as paid for by land constable to petitioner.
May please your lordship, the item number 4, lordship. Taken up next week, lordship. That's
Same order. 2 weeks. Item 4.
diploma.
Item 3 also, my lordship. Next
3
week, my
also.
lord.
Same 2 weeks.
All right. May I please, your lordship? I beg to mention item number 24, my lord. Matter may adjourn for a day, my lord. Only. My senior ISK is not well, my lord.
Item?
Item 24.
After a week. 24.
Lordship, item number 35 and 38, your lordship. After a week, your lordship. Mr. A. Ganguly is not keeping well today.
35 is a review matter of 2019.
Your lordship. Mr. A. Ganguly is not well, your lordship.
Okay, after a week. 35 and
38, your lordship.
38.
Much obliged, your lordship.
35 and 38.
Yes.
Wait, is the lordship. Lordship, I beg to mention item number 19, lordship. 19. Lordship, in this matter, conducting counsel, Mr. A.K. Gupta is out of station, lordship. Kindly matter may adjourn for 2 weeks, lordship.
19 after a week.
19.
May I please, your lordship? Lordship, I beg to mention for item number 22 and 36, lordship, for adjournment, lordship.
Twenty-two and 36.
Yes, lordship.
Okay, after a week.
God
Yes.
bless you, lordship.
Yes.
May it please your lordship.
Yes, yes.
I beg to mention item number 23. The matter may be adjourned for today.
23.
23.
Okay, 23 after a week. Yes.
Lordship, we are pleased to have the file of item number 30, your lordship. In the last order, it was stated that we are preferring an appeal. Another appeal, lordship, and both the matters may be heard together, your lordship. We found that there was a delay in filing the appeal, your lordship. Hence, we had to file an IA for continuation of delay, your lordship. That IA number being 3606 of 2024, lordship. May I pray that the matter may come up on Friday, lordship, along with the IA, your lordship.
Item 34.
30, your lordship.
30.
30.
You have informed the other side.
I've informed, lordship.
Size is represented. List this matter along with IA, civil
3606 of 2024.
on Friday.
Right.
That is 29/11. Okay.
Lordship.
May I please, your lordship? I beg to mention item number 32 with us. In this case, the petition number 1 has died. I have the instruction. Item 32, 32.
So what is your prayer?
My lord, that since she's dead, not her name should be struck out, my lord, and the proceeding may continue with the in respect of the other petitions.
Because if you are making a prayer for striking out, then please file an application.
Yes, my lord, I'll do that.
Yes. Because it leads to different consequences. Mr.
A. Ali.
A. Ali, learned counsel for the, say both sides are represented. So A. Ali, learned counsel for the petitioner has submitted that as per his instructions, the petitioner number 1 has died. Stop. Let the same be brought on record by way of an interlocutory application or and of the an affidavit. List after
At any time, after 2 weeks.
list after 2 weeks.
Obliged.
May I proceed? Item number 21. Any adjourn from today? LCR not received.
21.
Lordship.
LCR is not there. Check up LCR. Right. Okay. Both sides are represented. As the records of the tribunal is not received, the registry shall issue a fresh reminder for the records. Just after 2 weeks.
Reminder is met, madam. Reminder is sent.
Back,
Order-
please, your lordship. Lordship, 3 FT matters, your lordship. Their order will need to be corrected, your lordship. So I pray for listing of those 3 matters, your lordship. I'm deeply obliged.
Upgraded item 37 for orders.
My lord, may take it after some time, my lord. Mr. Ardhar is going to submit. He's on leg, my lord.
Okay. 37.
My lord.
Okay, after some time.
Item 1 for motion.
May I please, your lordships. This is a contested case, my lord. And the lauded tribunal, my lord, declared the petitioner, my lord.
Mr. Pang, you have seen the records? We are admitting it. But Mr. A.F. and you, Mola, learned counsel for the petitioner, also heard Mr. J. Paying Leonard, standing counsel for the FT matters representing
Whom the but
respondent
three,
numbers 3 and
5.
5. And Mr. H. Cooley, Leonard, counsel appearing on behalf of Mr. A. and standing counsel for respondent number 2. And Mr. P. Sharma, Leonard, additional senior government advocate appearing for respondent number 4. Now appears on call for respondent number 1 and 6. Next, madam. In terms of order dated 30/10/2024, the records, as called for is received. So it appears that the matter would require some adjudication. Also accordingly, matter is admitted for hearing without requiring the petitioner to take fresh steps. Stop. Place the matter for hearing in the month of January 2025.
My lord, may I pray for grant of bail, my lord? She is not on bail, my lord.
See, this is a matter of 2018.
Yes, my lord.
Please file an interlocutory application because now it is too.
My lord. It was supposed to be considered, my lord, on receipt of the LCR, my lord, and thereafter matter was not listed, my lord. Of course, there is, my lord, fault on my part because I should have either.
It's okay, we are not on fault, but it
There
appears to
gap-
be very
gap is there, my lord. Gap is-
too much of gap. We are not finding fault with you. But just to have the record straight.
I admit, my lord, my fault.
No, so we are not saying about your fault. We are not referring to it at all. Mishaps do happen, but please file an interlocutory application, we'll consider it.
Obliged, my lord, deeply obliged.
Item 5 for motion.
Wait, please, your lordship.
What is the explanation given for 2 years delay?
It's like a 4% lordship.
Even that must be stated. You have not stated that you are a poor person. So if we take a view, it will be defamatory for the petitioner. You have not given any explanation. Apart from the voters list, what document else you have?
Lordship, a copy of the calculation sheet of the petitioner father, Lordship. His father was working in Indian Railway, Lordship. Lordship, can you see page 45, Lordship?
You see, the difficulty is that you make submissions without reading the brief. You made a submission that he is poor. And then you have annexed his land document showing that 4 Katha 18 acres land is donated to him. Therefore, we said that it is defamatory for the petitioner. Don't make reckless statements. Yes, what is the document? You said which place, which page?
Lordship, page 45, Lordship. The school certificates are, Lordship, page 40 and 41.
No, this is merely a calculation sheet.
Yes, Lordship.
This is no proof at all. Nobody came to give evidence for this exhibit 6. So therefore, except for your voter list, you don't have any connect with your projected parents and grandparents. The cell deed is the cell deed is not a certified copy. It's not a original copy. Is it an original copy?
Lordship, I have collected from the tribunal, Lordship.
No, but is it original? It's a certified copy. What is it? It's a 50 rupees stamp paper. It can't be an original one. Where is your written statement?
Lordship, written
Or your
statement,
evidence?
Page 52, Lordship, 46.
So here you have not refer to the land documents. Where is your affidavit? Or your evidence?
I have not annexed the evidence. Lordship.
এইকেইটা
But this is no evidence at all. You did not exhibit any document. Somebody else came, Abdul Rao. Who is he? We don't know. He exhibits your documents. It's no evidence at all. How can somebody else, a third party, have your documents to prove it? It is not coming from the lawful custody. So your sale deed and your pension papers goes. Gambura did not come, that goes. School transfer certificate was not proved. That is gone. That is gone. The headmistress comes, but the document is shown, produced by this Gambura and the headmistress. They Prove the documents submitted by OPW3 2. The reason is possible. What is it? It's good to still look at that. Will give you protection not to be deported, but your prayer for bail will be considered on receipt of the trial court records.
Not sure.
This is what happens when the petitioner presented the brief without the lawyer knowing what document he's proving. He proves school certificate which says that the father is a cultivator. So your certificate that your father was a government employee is washed away. You don't prove these documents. But Mr.
M. Alam,
M. Alam, the counsel for the petitioner, also heard Mr. J. Pang, and it's standing counsel for the FT matters representing respondent number 2 and 4. Mr. P. Sharma, and additional senior committee advocate appearing for respondent number 3, and Ms. S. T. Khan, learned counsel appearing on behalf of Ms. P. Barwa, learned standing counsel for respondent number 6. By filing this writ petition under Article 226 of the Constitution of India, petitioner has assailed the opinion dated 29/1/2022, page 54 flag. Notice extra copy within 2 days. Call for the records. In the meantime, if the petitioner is not deported, he shall not be deported without the order of the court. The prayer for bail shall be considered on receipt of records. Next paragraph, the learned standing counsel for the respondent number 2 shall communicate a copy of this order. Oh, no, not required. It's not been apprehended. Just give date after in January for records. Can bill you. We'll consider and give you a date in January.
Maintainability may be kept.
Yeah, must be good.
My lord, maintainability may keep open because
Pardon me,
maintainability of the writ petition may keep open, my lord, because
just
there's
in the advance, before issuance of notice, the Learned standing counsel for respondent who has raised the issue of maintainability of the writ petition.
But
Then
not explained.
before notice, you say, keeping the issue of maintainability open, comma, issue notice of motion. Okay. But what is the reason for,
But not explaining the detailed assessment.
okay. Maintainability petition for not explaining the delay in approaching this court. Okay.
Highly apply.
Item 6.
I please, your lordship.
Yes.
Contested case, my lord. My lord, delay is there, my lord, 3 years delay. And I have stated in para 4 in my writ petition.
Para 4.
4.
Okay. And what is the best document to connect you
My
to
lord,
your projected
My
parents?
lord, voter list of
No, don't come to voter list.
My lord,
Any
Jamabandi
other
copy,
document? Huh?
Jamabandi land record, my lord, Jamabandi copy at page 34, my lord.
Which page is the opinion?
Opinion is, my lord, page 58.
58.
My lord, the relevant portion, my lord, page 60.
Just a moment.
My lord.
Where is the page number?
Jamabandi 34, my lord. Page 34. Serial number 7, my lord, his name. Rupsan. And my lord, serial number 8, my lord. Purpan, he adduced his evidence as DW2, my lord.
Just a moment. Serial number 8.
Serial 7 is the petitioner, my lord, Rupsan, son of Akkel. And serial number 8, my lord, Purpan.
Oh, there are 2 petitioners.
No, my lord, Purpan, my lord, serial number 8, he deposed as DW2, my lord.
Actually.
Then
You see, but still with that Jamamadi, nothing is proved. You look at the entry,
My lord,
look at the relevant entry. You are showing us this entry at page 34. Look
Yes,
at the Namjari order.
the order is, my lord, here Sokro become, my lord, bottom, right part of
Yes.
bottom, my lord. Sokro বিষয়ৰ 16-11-2018 তাৰিখৰ নামজাৰি নাম্বাৰ BAR/201/19/1305/FMUT হুকুম মৰ্মে 523 নং দাগৰ 3 কঠা 10 এচা মাটিৰ বাট পৰি যোৱা সূত্ৰে নামজাৰি শ্ৰী ইয়াছিন আলীৰ লগত শ্ৰী হাবিল উদ্দিনৰ লগত শ্ৰী হাবিল আলীৰ লগত আব্দুল্লাৰ লগত শ্ৰী ৰূপচানৰ লগত কুৰপানৰ লগত
So
Jamila
therefore,
Khatun,
how does it
Ita
prove,
Akkel Ali.
how does it prove that how do you prove that you are connected with someone? By purchase. So how does it help you?
My lord, this is, my lord, muted by way of inheritance, my lord.
No, please read it again. Inheritance is something we are not finding.
Yes.
How do you read inheritance?
চক্ৰ বিষয়াৰ 16/11/2018 তাৰিখৰ নামজাৰি নাম্বাৰ সোয়েনসো হুকুম মৰ্মে 532 নং দাগৰ 3 কঠা 10 এচা মাটি বাদ পৰি যোৱা সূত্ৰে নামজাৰি শ্ৰী ইয়াছিন আলীৰ লগত these are the legal heirs of Akkel Ali. ইয়াছিন আলীৰ
No, we
লগত
don't know about legal heirs.
হাবিল উদ্দিনৰ লগত
So it is along with. It's
Yes,
not
my lord.
not in
they are all
not by inheritance.
written like this, my lord.
Please read it. Don't.
Actually, my lord,
You see,
they are
do you-
all the legal
do you
heirs
think-
of Akkel Ali.
No. Please read it and tell us. Your smile will not help you.
Read totally.
Yes, my lord. লগত শ্ৰী হাবিল আলীৰ লগত আব্দুল আলীৰ লগত শ্ৰী ৰূপচান আলীৰ লগত কুৰবানৰ লগত জমিলা খাতুন পিতৃ মৃত আক্কেল আলী নামত নামজাৰি কৰা হয় লগত Yes, my lord.
Further, read further. Read further.
Registration deed number no, deed value 0, লাটমণ্ডল রত্নেশ্বর দাস চক্র বিষয়া মানব কুমার
So
হয়েছে
according to you, on inheritance, the man before dying will execute a sale deed for inheritance. No, you just said that it was inheritance.
sale deed number nil, my lord.
So that is nil, that is your lookout, but it is sale deed. So dying man did not execute the sale deed as inheritance.
My lord, bottom, my lord, kindly see my lord, my lord, 1, 2, 3, fourth line, my lord. From top. চিঠার উত্তরাধিকারী সূত্রে 3/4/88 হুকুম মতে পট্টার 1, 2, 7, 3, 5
Mr. Counsel, that is Upaproti Samaharta,
Yes.
not Uttaradhikari
Yes,
Utre.
yes. Property homeowner.
That is,
Which is not there.
Yes.
that is sub-deputy collector
Yes.
in English.
দাগৰ সমুদায় জমি জমাত আক্কেল আলীৰ স্থলত ইয়াছিন হাবুল আব্দুল রূপসান কুরবান নামত নামজারি করা হয় in place of my lord their father Akkel Ali. And my lord, in the bottom, my lord, 3 kotha 10 lesa, that land was left out, my lord. From the total land. Total land was, my lord, 1 bigha 4 kotha 13 lesa.
The street was the land originally is a sold land. Doesn't prove your antiquity with your projected parents that they were the Indian citizens before 1971.
Lord, his father's name appeared in the voter list of 1965-1970. My lord, his elder brother, my lord, his step elder brother, he deposed, my lord, but no discussion is at all in the opinion, my lord.
That discussion you will find in paragraph 10.
Then, my lord, evidence of OPDW1 and that of his stepbrother, Purbanali DW2, is not supported with documentary evidence. And hence their evidence stands rejected. Only this line.
So
My lord,
the one line is sufficient.
Both's name is, my lord, equally at the, my lord, serial number 7 and 8. Their name is there, my lord. And their name has been muted in place of their father.
Yes, Mr. Pine.
Let the record.
But Mr. S.A. Ahmed, learned counsel for the petitioner. Also heard J. Pine, learned standing counsel for the FT matters representing respondent number 3 and 6. And Ms. S.T. Khan, learned counsel appearing on behalf of Ms. P. Bajaj, standing counsel for respondent number 2. And Mr. P. Sharma, learned additional senior government advocate appearing for respondent number 5. So there is no representation from respondent number 1 and 4. Finding this repetition, the petitioner has sealed the opinion dated. Which is page 59. By so and so, rising out of PE number so and so, in so and so. They were declaring the petitioner to be a foreigner of post 25/3/1971. Notice call for the records. Petitioner shall appear before the Superintendent of Police border Kolkata within 10 days from the day of the order, and the furnish a bill bond of rupees 5,000 with one surety of like amount with all those conditions. Before that, requisite extra copies, please.
Oblige.
10 days time to take bail.
Item 7.
May I please your
Yes.
lordship? It is a contested case, my lord. My lord, after having reference, the petitioner appeared before the honorable court, filed WS.
What is the explanation for delay? Really, you have not explained. And what is the best document to connect you to your projected parents?
My lord, at first, my lord, I can see page 11, para 2. The petitioner begs to state that she had studied in Sabgor HM Academy School, SS School till 12/6/93. In this regard, the headmaster of the said school issued school living certificate in favor of the petitioner. Annex 1, page 30 to 31.
Page number?
30 and 31. And the linkage certificate is, my lord, 32 and 33. Which was exactly next 2. Linkage certificate. Kabil Lama is 34 and 37. My lord, petitioner grandfather appeared in the NRC of 1951.
This is the last voters list of your father, which you have exhibited.
A copy of voter list 1997, Arthur.
Then if the father is not there after that, that means the father is not there after that. So who deposed as your father?
My lord, grandfather of the petitioner enrolled in the voter list, my lord, 1966, my lord.
No, your father deposed on 11/3/2020. Before that, he's not there. Mhm. Hmm. 18 years.
Indian soil is recorded from 1957.
My lord,
The only voters list of your father is 1997.
1997 and also, my lord. Grandfather voter list, my lord, page 44, 45, 1966, my lord. Page 44, 45.
It's not exhibited. Page number?
44 and 45.
Was it exhibited?
Is it, my lord? 44 and 45. $45 million.
It's not
Makes-
exhibited. We are time and again telling you, if you are relying on a document which is not exhibited, please tell us. But you make us read and then find out for ourselves. You are misleading the court. We are not protecting you by bail. We are just saying that you will not be deported. You must make it very clear when you make your submissions, which is an exhibited document, which is not. So it's clear to us. Not saying that means that you are misleading the court. Why should we take the trouble of reading and finding it out for ourselves? You could have said, but Mr. A. Das, Leonard, counsel for the
Well,
petitioner.
my petitioner is,
No, we are not protecting you with bail.
my lord, deposition, my lord, deposition of father.
We are
deposition-
not protecting with bail. Once you don't tell us and we have to find out, then we are not protecting you.
My lord, my petitioners beg to state that the name of the petitioner has been enrolled in the voter list of 2005, along with the husband and mother-in-law, serial number so and so.
By filing this repetition under Article 226 of the
10.
Constitution of India,
Exhibit 9 is
petitioners assail the opinion dated 17/3/2022, page 106, passed by so and so and so and so. Thereby declaring her to be a foreigner of post 25/3/1971. That's the learned standing counsel for the, no, sorry, also heard. We did not say Mr. A. Das, fortunately, also heard.
Kindly see,
Mr.
W, my lord.
J. Pang Leonard. Standing counsel for the FT matters representing respondent number
2 and
2
6.
and 6. And Mr. A.I. Ali Leonard, standing counsel for respondent number 3. And Mr. P. Sharma Leonard, additional senior government advocate representing respondent number 5. There is no representation from respondent number 1 and 4. Next, opinion dated so and so is, by filing this repression, so and so opinion is sealed. Next, the Leonard standing counsel for the FT matters has objected to the admission of the repression on the ground that there is no explanation for the delay in filing this petition.
My lord,
Next, keeping the issue of maintainability open, issue notice returnable on so and so January.
Notice this,
This
notice.
one so and so. Requisite extra copies of the petition be served on Leonard CGC, State and Departmental Council within 2 days. Next para. Let the relevant records be requisitioned from the Learned Tribunal. Next para. In the event the petitioner has not been deported, she shall not be deported without express order of the without order of the court. Next para. The prayer for bail shall be considered on receipt of the records of the tribunal. List on so and so. We are not protecting you unless you come out straight. You should have told us in advance. You should not have allowed us to read and find out.
acknowledged, my lord. In W, it is acknowledged. In W, written instrument, my lord.
Next item.
Next. It is not as shared question, notice issue.
No, no.
Depot করবো না বলবো?
Wait, wait, ঠিক আছে।
Not to deport.
We are protecting you not to be deported, nothing more.
Item 8.
Acknowledgement.
May I please, my lord? My lord, this is a contested case, my lord.
What is the best document you have
My lord,
apart from voter list?
apart from voter list, my lord, sale deed of 1965, my lord.
1965.
Yes, my lord. Page 26, my lord.
Was it exhibited?
Yes, my lord. Executed.
Page number?
Yes, my lord. 25, my lord. 27, my lord. His father's name has been, my lord, dear, my lord. Hamid Khan.
Okay.
My lord,
These are good, huh? Okay, had Mr. S. A. Ahmed, constable petitioner. Also heard Mr. J. Pang, standing person for the FT matters representing respondent number 3 and 6. And Ms. S.T. Khan, that counsel appearing on behalf of Ms. P. Barwa, then standing counsel for respondent number 2. And Mr. P. Sharma, then additional senior government advocate appearing for respondent number 5. There is no representation from respondent number 1 and 4. Next one. Filing this repetition under Article 226 of the Constitution of India, petitioner has exhaled the opinion dated 30/5/2024, page 93, passed by so and so. In case number so and so, represent arising out of reference IMDT case number so and so. By declaring the petitioner to be a foreign of post 25/3/1971.
Yes, everything.
It will work with you, no?
কিশোর মই কেন করেছিল কিশোর যাতে আলে গম পায় ওটা আপনার এখন সময় বেঁচে গেল গেলে গিয়ে যদি সাকসেস হয় না Where is the sale deed? Where is the sale deed?
Shall it, my lord, page 26. And 27 is the, my lord, original copy.
Okay, submitting the voter list with his name is recorded and it is further from the same house.
Is the cross-examination of DW available?
DW, my lord, DW1 is OP, my lord, 2 is his brother, my lord. Cross at page 84, my lord.
I have not lost it. Vote with you. I have not submitted vote.
Okay.
Issue notice extra copies within 2 days. Let the relevant records be called for from the learned tribunal. Petitioner should appear before the superintendent of police within
Bongaigaon.
bracket border, Bongaigaon, within 10 days. Below release 5,000 with all those conditions. Failure to appear, bail will stand cancelled.
Obliged.
Item 9.
My lord, there is also delay, my lord. The opinion was, my lord, passed 16/7/2022. And I have stated the ground, my lord, at paragraph 4 of my petition. And in this case, my lord, father and mother deposed as DW 2 and 3.
There is an unexplained gap
Yes, my lord.
for a long period.
Yes, my lord. That is, my lord, due to financial hardship. and lack of proper guidance. And my lord, she could not, my lord, contact with her engaged counsel. My lord.
No, you see, there are many lapses. The tribunal has given a finding that there was your father and mother were not together. And you seem to have been born in 1984. That time, your parents are not together in the voter list.
My lord, 1997, 1989, my lord, grandparents and father's name.
So your mother is not there. When
Mother
you are
is
born
not
in
there.
1984, how?
1997 first, mother and father. Her
No, we are
parents.
also looking at your entry into the country. If you're born here, your mother is not there. Your mother only comes in 1997.
Yes, my lord. At the age of 30 years.
There's no document to connect you to your parents. Except for oral evidence.
My lord, her father's name appeared along with my lord, her grandparents. In the
That is
voter
only
list of-
oral evidence. If you can't connect yourself with any document,
Not only. My
what
lord,
is this not a proof of
father and
parentage?
mother deposed, my
Hmm?
DW 2 and 3.
Who?
Father and mother. Parents deposed, my lord,
Mother,
as
the
DW
mother
2 and
herself
3.
is not there. During the period of birth, your mother itself, her presence is not there.
Father is there, my lord. Father also deposed as DW 2.
This lady is wife of item number 6. This lady is wife of the petition in item number 6. Actually.
No, my lord. No, no.
No, they are different people.
Different people.
Hmm.
Sania, yes, my lord. Rashida Begum, my lord.
Has to be same because somebody says Sania Ali is his name. Has to be same.
Same, Akel Ali. Father is Akel Ali. Same.
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 Sania Ali. Yes, my lord. Yes.
Yes. You don't know. We have to
Sani.
find out. Wife of Sani Ali, Rusan Ali.
Elias Sani.
Elias Sania Ali.
Elias Sani, that is what is ringing bells.
Father is Akel.
Akel.
Father is Akel.
Rusan's father is Akel Ali.
Yes, sir.
Rashida Begum, Sani Ali. Rusan কি করা হয়েছে?
Yes.
बिल भी आ सकता है.
Item 6 to the first.
बिल भी छो. इसको होना लगे. बिल. देखो 6 बिल भी छो. But Mr. S.A. Ahmed, then counsel for the petitioner. Also her Ms. S.T. Khan, actually appearing on behalf of Ms. P. Barwa, standing also for respond number 2. Mr. J. Pine, it's standing also for the FT matters representing respond number 3 and 6. And Mr. P. Sharma, additional senior government advocate appearing for respond number 5. Mr. Datta is there.
sir.
Sleep disease, sir. For one, Mr. A.K. Datta, CGC for respond number 1. This petition, opinion dated 16/7/2022, page 63. Notice extra copies within 2 days. All for the records. Petition shall appear before the Superintendent of Police order, Borpeta, within 10 days, below rupees 5,000. Failing to appear, it shall stand revoked. 10 days time to take bail.
Obligement.
This case has nothing. You are getting by default. Getting bail by default. Because you gave your husband bail.
Obligement.
Item 10.
May I please your lordship? Final order dated 30/11/2023 passed by the learned member Furnished Tribunal, second Borpeta, my lordship.
Just
My
a-
lordship, page 40,
just
final order,
page number
40,
40.
40.
23, delay of 1 year.
Delay 1 year, my lordship. I have mentioned the ground of delay, page 14 in my requisition, para number 23.
What have you said?
My lordship, the requisitioner is an old lady and income is about 67 years, living on the support of her relatives and other well wishes.
67.
67 years, my lordship. The petitioner live alone and totally dependent on what she can earn as a domestic help. The petitioner had spent considerable time while organizing the finances to enable her to file this petition, my lordship.
Mr. Pang, 67 years we're giving bail. And Islam, that counsel for the petitioner. Also had Mr. A. Ali, standing counsel for respondent 2. Mr. J. Pines, standing counsel for the FT matters representing respondent 3 and 5. And Mr. P. Sharma, an additional senior government advocate appearing for respondent 4. And Mr. A.K. Datta, an CEC appearing for respondent 1. There's no representation from respondent 6. Page 40, opinion dated 30/11/2023. Notice extra copies within 2 days. Call for the records. Petitioner shall appear before the Superintendent of Police, Border, Baksa, Amul, within 10 days and take bail. Default non-appearance, the bail shall stand revoked. 10 days time to take bail.
Any of this?
Item 11.
11, my lord, there is also some delay, my lord, 1 year delay, my lord. And I have stated in my writ petition at para 4, my lord. And in this case, my lord, mother of the petitioner deposed as DW2.
Where is this where is this deposition and cross-examination?
My lord, page 56,
50?
56 is the cross of DW2, my lord. 56 is the, my lord, type copy, and original copy start from page 58, my lord. Mother is, my lord, 79 years.
But there is no document to connect you. You have
My
used
lord,
your grandfather, father, but
my lord, mother deposed as DW2 and her name appeared in the voter list of 1970, my lord. And my lord, one more documents, my lord, is school certificate of the petitioner. Exhibit, my lord, that was exhibited documents at page 32.
but school principal did not come.
Yes, no, my lord. But exhibited documents. My lord, her mother, my lord, 79 years old lady, my lord, she deposed before the tribunal.
The presence in the last 50 years is not there. Suddenly somebody appears as mother.
My lord, 1970, my lord, the voter list of 1970, her name is there, my lord.
After
Yes.
70, which is the next voter list?
Next voter list, my lord, not exhibited, my lord.
It's not there. She suddenly appeared as a witness only.
65, 70,
So after 50 years, she appears.
She was surviving,
yes, ma'am.
but her name is not reflected anywhere in between.
Reflected, but that voter list, my lord, perhaps they did not exhibit, my lord.
Counsel, perhaps is not possible. Either yes or no.
Just not there. Minutes. They're not inclined to give you bail.
Mother,
Your mother,
never till lie, my lord.
your mother doesn't even know when you were born.
She, my lord, clearly stated that the petitioner is her daughter.
So that is okay. Any tutored witness will say that. But when you ask when she was born, she said, I don't know. How can a mother not know when the child is born? If she's coming to depose before the court, tribunal, then she does not know when her own child is born for whom she is coming to depose. 50 years her absence is not explained. You say you're not to be deported. You're not inclined to give you bail. But S.A. Ahmed then counsel for the petitioner. Also heard Mr. A.K. Dattal and its CGC appearing for respondent number 1, Ms. S.T. Khan, learned counsel appearing on behalf of Ms. P. Barba, standing counsel for respondent number 2. Mr. J. Pang, learned standing counsel for the FT matters representing respondent number 3 and 6. And Mr. P. Sharma, learned additional senior government advocate appearing for respondent number 5. Find this replacement in Article 226 of the Constitution of India. Petitioner has sealed the opinion dated page 61, 9/1/2023, passed by so-and-so in so-and-so, thereby declaring the petitioner to be a foreigner of post 25/3/1971. Should notice returnable on, so she will give a date, January sometime. Returnable on so-and-so. Requisite extra copies of the petition will be served in the CEC, State and Departmental Council within 2 days. Let the relevant records be requisitioned from the concerned tribunal. Next paragraph. In the event the petitioner is apprehended, she shall not be deported out of the country without order of the court. Next paragraph. Prayer for bail shall be considered on receipt of the records of the tribunal. List on so-and-so.
7th of January.
Oblige.
Item 12.
Maybe the Lordship.
Yes, what is your best document?
Lordship, to annexure 3, page number 39, Lordship, one certificate has been issued by the Block Development Officer, Lordship, Tuffanganj, Coast
Page?
Bihar. Page 39, Lordship.
39. Something is wrong. You're showing us exhibit, this annexure 3, page 39.
Yes, Lordship.
This is exhibit.
GB, Lordship. Exhibit 1, Lordship.
Exhibit 1. Did this video come and depose in favor of you?
Yes, Lordship.
He was a witness.
No, Lordship, testimony of the, page number, Lordship, 35, finding is. Testimony was not done, Lordship. Before tribunal.
The only good thing here is that DW 1 and 2, they are fantastic witnesses. Whatever DW 1 has said, DW 2 has said the opposite. No statement of theirs match. So you only say your application for bail will be considered on receipt of records. Will not be deported by them. In every statement, there is a mismatch. This one is so interesting. Mr. J. Hatimoria. Heard Mr. J. Hatimoria, learned counsel to be. Please make it a habit to take care of your advocate's clerk. He'll lead you to some difficulty. Take care of your clerk, otherwise you'll be in difficulty sometimes. They have changed your name. And suddenly will require your affidavit. You got it? No. We'll pass you after we pass the order, we'll send you this file. Look at that. And, so also heard Mr. A.K. Dattar and CEC appearing for respondent 1. Mr. G. Sharma and standing counsel for respondent number for the FT matters presenting respondent number 2 and 5. And Mr. P. Sharma and additional senior government advocate appearing for respondent number 4. There's no representation from respondent number 3. Filing this petition and Article 26 of the Constitution of India. The petitioner has assailed the opinion dated 15/2/2024, page 32 by insuance by so. Thereby declaring the petitioner to be a foreigner of 25/3/1971. You should notice returnable in 4 weeks. Revisit extra copies within 2 days. Let the relevant records be requisitioned from the learned tribunal. Next slide. In the meantime, it is provided that if the petitioner is not deported, she shall not be deported out of the country without order of the court. Next slide. Prayer for bail shall be considered on receipt of records. List on which date? 7 January. Notice returned on 7 January. We are sending you this file. Look at page, the first page. We'll take a short break and come back. What is the explanation for delay of 2 years?
Delay of 2 years, I have explained in my paragraph number 16 at page 10 of my petition. That after filing of the DW1, the DW2 before the learned tribunal, as aforesaid, the petitioner fell severely ill and the petitioner became bedridden. The doctors diagnosed the petitioner with severe LBA, radiculopathy, a type of nervous ailment in the month of March 2021. The petitioner underwent continuous treatment and medication for the same. For a period of 2 years, the petitioner remained bedridden on account of the aforesaid nervous ailment. After the petitioner recovered a bit, the petitioner suffered from swelling over chest and epigastric tenderness, which resulted in continuous chest and stomach pain. For the aforesaid health problems, the petitioner underwent continuous treatment for another 1 year. In the later part of the month of October 2024, when the petitioner met her engaged counsel and inquired about the aforesaid FT case number 836/2017, the said counsel informed the petitioner that the aforesaid FT case number so-and-so has been disposed of by the learned tribunal by final order dated 17/9/2022, and that the petitioner has been declared a foreigner post 25/3/1971. Finding no other way out, the petitioner, accompanied by her son, traveled to Guwahati, engaged the present set of counsel, and handed over the brief of the case to the said engaged counsel The present set of counsel having gone through the brief of the case, prepared the instant petition, and thereafter the instant petition was filed before the honorable court. And medical documents have been annexed 13 series.
What is the best document you have to connect you to your projected parents?
Kindly come to page number 23A. Page number 23A is a part of the Jamabandi, that is remark on the right hand side, remark column.
It's an exhibited document.
This was not exhibited.
Then please tell us in advance that it's not an exhibited
Not
document. We
exhibited.
don't want to. That would mean misleading us. Amongst the exhibited document, which is the best document you have?
Apart from the voter list, the Gaubura certificate at page number 28.
The Gambura was not examined as witness.
Was not examined. Even DW1 and the DW2 also didn't appear for cross-examination.
Then we have nothing, but since the petitioner is ill, we are granting bail. Mr. Sharma,
Yes, Lord.
there's nothing here, but
Yes, Lord.
and what is the reason you have explained for not standing in the dock for cross-examination?
She was bedridden at that time. The petitioner was bedridden.
Mr. A. K. Dattar and CC appearing for respond number 1. Mr. B. G. Sharma, learned standing counsel for the FT matters representing respondent number 2, 3, and 5. And Mr. P. Sharma, learned additional senior committee advocate appearing for respondent number 4. And Ms. S. T. Khan, learned counsel appearing on behalf of Ms. P. Barwa, standing counsel for respondent number 7. Filing this representation under Article 226 of the Constitution of India, or the petitioner is assailed. The opinion dated 17/9/2022 passed by so and so in page 56. Thereby declaring the petitioner to be a foreigner post 25/3/1971. Issue notice returnable in 4 weeks. Requisite extra copies of the petition be served on the Honored CGC, State and Department Council within 2 days. Let the relevant records be requisitioned from the concerned tribunal. Petitioner shall appear before the Superintendent of Police within bracket border, Borpeta, within 10 days, when below is 5,000 with those conditions. In the event of default on part of the petition to appear before the said authority and take bail, the order of bail shall stand. Revoked by effects of time. Next. List after 4 weeks on receipt of records from the tribunal. This, before that, you say. Just before the last line, you say that the petitioner shall file translated copy of Annex 3, Roman 3, by way of an additional affidavit on the next date of listing. Translated copy, please file.
Item 14.
Copy of list.
Maybe lot.
Yes.
Sinful opinion page, my lord, 89.
89.
89. The long opinion.
It's a very long opinion.
30 page, my lord. Only I have gone through the report only, my lord. They had the Gaura deposed and the Gaura used the state emblem that was not considered. And
Please repeat again, Mr. Ali.
my lord, page, my lord, 150, my lord, that part, my lord, 24. Here the 2 Gaura deposed and issued the certificate before the honorable court.
Yes.
And that was rejected on the ground, my lord. Page 105 last part.
Yes.
24, my lord.
Yes.
However, both the certificate exhibit G and H issuing the authority had used the state emblem, the certificate without any legal sensitivity, and this regard, the Honorable High Court held that any legal sensitivities on the issuing the date of a senior emblem, the document itself, it's individual, need individual. That's done, my lord, and the petitioner, brother also deposed, Gaur also deposed, DW 3 and 4, my lord. And GP secretary is issued the certificate, but he has not deposed the court, my lord. As a linkage for the school certificate also.
But the DW2 has failed you. DW2 could not prove anything. His own identity could not prove.
My identity is used, my lord, the voter ID, where is his father name appeared, my lord. But he, the petitioners and DW2 is the brother, my lord. There is no any linkage with voter list, my lord. That document, my lord. But the father, the PW2's document, voter ID, other document shows that petitioner father name is Somir, my lord, Shakimuddin, my lord. That party, yes, my lord. And written statement also stated, my
But
lord.
his name is different. He's not your brother.
And petitioner, my lord, brothers also, the written statement, my lord, he deposed, my lord, he is my brother. And written statement, my lord. Written statement, my lord, page 141, my lord. The following the brother and sister.
Many things multiply and then gives a negative feeling. The son said he does not know when the father died.
Long back that part, right, the long back, my lord. But actually, my lord, in a right, then father died in 1987. My lord.
A member of the family, is it possible somebody will not remember when the father died?
Exact date was not mentioned, my lord.
Year. Did he say?
My lord, 1987, my lord.
Did he say? Wait.
My lord, DW2, written statement, my lord, says, my lord.
No, evidence.
Evidence, my lord, there no specific document, my lord, but and petitioner name in 97 that the D voter was included.
That's why you see, these dates are relevant. And if the dates are not given, how do we understand which document is being proved? What is the evidentiary value of that?
Come to page 63.
Yes, my lord.
8 line.
I do not know where my parents and grandfathers were.
I do not know the date of year when my father and mother was expired. Date was not there.
No, date is not. Year.
My lord, the
How
tribunal.
old is he? How old
My
is
lord,
he?
my lord, kindly see tribunal.
68 years.
My lord, tribunal asks, my lord, page 51. The ladies, my lord, the petitioner asks the when your mother and father married, when the date of marriage. Such question.
Come 7, 8 lines below.
Page 53, my lord, no?
63. I do not know when my parents were born and brought up.
And he does not even know where my parents and grandparents have been resided.
I do not know my grandfather's mother's name.
That part, my lord, I am admitted, my lord, but kindly see, my lord, page 51, the question, my lord.
You see, 1 + 1, when it becomes 2, and
When, my lord, the tribunal,
becomes
ladies,
dangerous.
from the tribunal asks, first, my lord, comes 51, my lord, the question, my lord. I do not know, the tribunal asks, my lord, I do not know when my father married and my mother, Zulekha Bibi. I do not know what age my parent got married. My lord, it is possible, my lord, father when married, how married, the
So
date.
definitely, I know when my parents were married.
You lordship and
64.
that I am admitted, my lord, that part. I am admitted, my lord. That. Regarding my lord, toast, my lord, I admit it, my lord. That is not dispute, my lord. But my lord, both the Gauhura are deposed, my lord. And the question, my lord, the tribunal question, my lord, ladies when informed the tribunal, my such question is asked, my lord, automatically he nervous, my lord.
Section 50 comes to the fore. Now we cannot rescue. Your brother is deposing like this. পহিলে যেটা মার্ক করে শেষ করো
The Aurora certificate was rejected not only because of state and lordship. Para 23 was discussed based on the.
I think we are not finding anything on merit. Document goes. DW4 is the Gambura.
Yes, my DW4
3.
and DW3, both are Gaubra, my
The DW4 evidence is also worse.
DW4, my lord, and DW3.
DW4 evidence is worse.
DW4 is the, my lord, resident of his parents' sides, my lord. Shokabausi, Krishna born that place, my lord.
Okay, so section 50 evidence আমরা restore করবো নয় আর কি।
Okay, Mr. Ali, we are protecting you, but your witnesses have done a wonderful job. The more we read, we are finding it more interesting. Had Mr. H. Ali Lanet, counsel for the petitioner, also heard Mr. A.K. Dattar and CGC appearing for respondent number 1, Mr. A.I. Ali Lanet, standing counsel for respondent number 2, Mr. G. Sharma Lanet, standing counsel for the FT matters representing respondent number 3 and 6, and Mr. P. Sharma Lanet, additional senior government advocate appearing for respondent number 5. There is no representation from respondent number 4. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 4/4/2024, page 89, passed by so and so in so and so. Declaring the petitioner to be a foreigner of post 25/3/1971 stream. Issue notice returnable in 4 weeks. Requisite extra copies of the writ petition be served on the runner. CGC, State and Departmental Council within 2 days. The petitioner shall appear before the Superintendent of Police, Border, Borpeta, within 10 days and take bail on rupees. Furniture bail bond rupees 5,000, same language. With one surety of like amount to the satisfaction of the said authority. It is made clear that if the petitioner does not appear before the said authority and take bail within the time allowed, the order of bail shall stand lapsed due to reflex of time. List after 4 weeks on receipt of records from the tribunal.
I love this.
Item 15.
May I please, Your Lord? My lord, in this case, apart from the my lord, series of voter list, my lord, recorded in the name of the father and grandfather, my lord, the petitioner
Which
submitted
page
on
is the opinion?
my lord, your opinion, lordship will find at page number 94 onwards. my lord.
Page number
94 onwards.
94.
Basically, why the tribunal disbelieve the case of the petitioner? Your lordship will find at page number 102, paragraph 27.
Which page is the Kabirnama?
Kabirnama, your lordship will find. At page number, my lord. 63, my lord. That is the type copy, my lord. And then 64 and 65 is the particular.
Which page is the evidence of DW1?
DW1, my lord. It starts from, my lord, connection 2. That is, my lord. Page number 40 onwards, my lord. That is the evidence in chief, my lord.
40.
40, my lord.
But
Yeah,
Mr. A. Ali, learned counsel for the petitioner, Also heard Mr. A.K. Dattal and it's for response number 1. Mr. G. Sharma and standing counsel for the FT matters representing response number 2 and 3. 2 and 3. Mr. P. Sharma and election officer will be Mr. Sharma, I think. Huh? Mr. P. Sharma and standing counsel for additional senior government advocate appearing for response number 4. And Mr. A.I. Ali, Leonard standing counsel for the election for the response number 6. So there is no representation of response number 5. Nobody change in opinions. Rest is same. Opinion dated 21/5/2024. Passed by so and so, page 94. They were declaring the petitioner to be a foreigner of post 25/3/1971. Same thing, notice, call for the records. Extra copies within 2 days. Petitioner shall appear before the Superintendent of Police, Border, Bajali, Bajali. Within 10 days, take bail. Failure to appear, the bail is revoked by flux of time or lapsed. List after 4 weeks on receipt of records from the tribunal.
I am obliged.
Item 16.
May I plead the lordship? Your lordship will find the opinion at page 61, annexure 19, my lord.
Page
61, my lord.
61. We don't find any explanation for the delay.
My lord, actually, there is no any such justifiable ground for delay. Probably, my lord.
We'll consider the prayer for bail, receipt of records, but we'll say that you will
my
not be
lord,
deported.
but he has not been apprehended till now, my lord.
You will not be deported.
Yes, my lord.
But Mr. D.P. Baral and counsel for the petitioner. Also had Mr. A.K. Dattal and CCC appearing for response number 1. Mr. G. Sharma and standing counsel for the FT matters representing response number 2, 3, and 7. Mr. A.I. Ali Leonard standing counsel for response number 5. And Mr. P. Sharma Leonard additional senior government advocate appearing for response number 6. There is no representation for response number 4. The opinion number will change. Opinion dated 29/12/2018. Passed by so and so, page 61. They were declaring the petitioner to be a foreigner post 25/3/1971 stream. You should notice returnable on 7/1/2024. 25. Is there extra copies within 2 days? Call for the records. In the interim, it is provided that the petitioner shall not be deported out of the country without order of the court. Prayer for bail shall be considered on receipt of the tribunal records. List on 7/1/2020. 5.
Right.
Item 37.
Was called in the this upgrade item was. I'm praying for this I has been filed for grant of bail lordship. He was arrested on 2/9/2024. But there is no explanation regarding the delay in the petition lordship. The opinion is of dated 11/01/2022.
22. When were you apprehended?
Apprehended on 2/9/2024. In paragraph 7, page 9, I have stated why the delay was there. But in the writ petition, there is no explanation.
Mr. Sharma, 2 months. No, the business is deciding.
No, I filed it on last Friday, lordship.
You filed your Kalapam?
Yes, lordship, on last Friday.
So our third learned counsel appearing. Appealing for the petition for the applicant. So he has submitted that he has filed his Wakalatam on
Friday, lordship, last Friday.
Friday on 22
22.
11/2024. If that be so, the said Wakalatam will be tagged with the record. Next paragraph. Mr. A.K. Dattar and CC appearing for respondent number 1. Mr. G. Sharma and its standing counsel for the active matters representing respondent number 2 and 3. For Mr. P. Sharma and an additional senior government advocate appearing for respondent number 4. And Mr. A.I. Ali and its standing counsel for respondent number 6. There is no representation from respondent number 5. Next paragraph. By filing this interlocutory application, applicant was apprehended on 2/9/2024 and detained in custody. Is prayed for a release on bail. Next, the prayer for bail is opposed by the learned standing counsel for the active matters. On the ground that after the opinion dated 11/1/2022, the applicant could not be found and she could be apprehended only after a lot of effort from the concerned police authorities. It is submitted that if granted bail, there is a weak likelihood that the petitioner may abscond. Next paragraph. In view of the fact that the petitioner has been, the applicant has been apprehended on, what is the date?
2/9/2022.
2/9/2022. And more than 2 months has, and she's in custody for last more than 2 months. What is of the constitutional opinion that in view of the period of custody already suffered, the petitioner be released on, the applicant be released on bail on the following conditions. Number one, that the family members of the petitioner, applicant, sorry, shall appear before the superintendent of police within bracket border Borpeta and furnish bail bond of ₹5,000 along with one surety of like amount to the satisfaction of the said authority. Full stop. On a within 3 days from the date of receipt of a certified copy of the order as well as all the requisites for bail, the superintendent of police with the bracket border Borpeta shall take necessary steps to have the applicant, namely
Monowara Begum.
Manowara, Manowara Begum, released from the transit camp, Matia, Gwalpara. I have brought to his office for recording of the, for capturing the iris of both the eyes as well as for taking the fingerprints of both hands. And shall take the necessary particulars as per the rules and then undertaking to appear before the court of the tribunal as and when directed. Full stop. After set formalities, the applicant shall be allowed to go on bail. Next paragraph. As a condition of bail, it is provided that the applicant shall not leave the territorial jurisdiction of the superintendent of police border Borpeta without written intimation to the said authority. In the event the condition of the bail is violated, it would be open to the respondents to move this court for recalling of the order of bail. Next paragraph. Application status allowed and disposed of on terms as indicated above. And in the well, also as a represented, the registry should take a shall issue fresh reminder for the records of the tribunal. List after 4 weeks on a date to be fixed by the registry. So in the first line, you have said all sides are represented. All sides except respondent number 5 are represented. You have received telephonic instruction.
Verbally, they have asked to appear in respect of NRC lordship, but that notification was still not getting lordship.
Deeply observed.
Waived legal lordship. My lord, earlier, bail application was rejected in this case. But after many days, that is, I am behind the bar 6+5 months, 13 days. And my case is this, my lord. Just after, on the point of delay, just after the opinion was declared, within 30 days, I engaged an advocate. That I have already stated. That is respondent number 8. And her statement is also there. Her statement, which was recorded by my lady client, a client's wife. So, my lord, what happens? This person, just after the order of the learned tribunal, appointed an advocate. That is respondent number 8. She took money, etc., and said that I have done everything, nothing to be worried. And next day he asked me to come, and I came with money, but during the night I was arrested. That is on 22/7/24. Since then I am behind the bar, and my health condition is extremely bad. Already in IA I have annexed the document. Kindly say IA, page 17, my lord. The type copy is page 16, and doctor has advised him to undergo medical surgery in GMCH. Page 16, kindly see, my lord. Of the IA, 16 of the IA. He was transferred to Gwalpara Hospital, civil hospital, by the police from the detention camp, considering his critical condition. Then he was there for 5 days. Then he was advised to go to medical college at GMCH. And my learned friend would be able to know about his condition extremely bad. So, my lord, my only prayer is this: let him grant bail, and then lordship maybe call for the records.
Yes, what is the disease? I can't read. Page 17.
Yes.
Diagnosis. What is the diagnosis? I can't read.
It is investigation report. We also could not so much understand. This is medical hospitals. So it is date and time of admission 9/9/24 at 3:30. Indoor register number so 2350/24. Date and time of discharge 25/9/24 at 8:15 p.m. 8:50 p.m. Then diagnosis P40 is.
No, but what is the disease? We can't read.
But I have been told, I also cannot properly understand because doctor's lingo, but I have been told she needs to go surgery for blood, for, no. Appendix, appendix and gallbladder.
No,
But his condition is critical, my lord. If your lordship kindly desire, he may take information from the detention of just now. His condition, he is totally bedridden. Not only this time, since last 1 month, he is totally bedridden. And I am behind the bar since last 5 months, 13 days. Huh? Oh, sorry, 4 months, 16 days.
No, no, something is wrong. Because in the page 17, the first words are PUO. Page 17, diagnosis PUO.
Yes.
It is
That's-
pyrexia of unknown origin, which is just fever. Cause unknown.
No, it is more than favor, my lord. If your lordship be pleased, my learned friend may take information from the detention camp. He is totally bedridden since last 1 month. Actually, in Goalpara, there is no such facility which requires this patient. That type of facility is not available at Borbita, at Goalpara. Now one by considering his period of detention, my lord. 163 days. And then he will come and will be able to take proper step against the lawyer whom he engaged. Below investigation report CT scan, it is written. CT scan, let us see CT scan. And X-ray, X-ray, CT scan. Otherwise, my lord, I have a good case also on merit. Some documents I could annex, but majority of the documents are with the lawyers. But the landed tribunal has stated here about my documents, page 61.
Because there's no connecting documents. That is what we were
No,
looking at.
connected
There's no
documents are
document to
there.
connect you to your projected parents.
No, my lord, may see, page 17 is the 66 voter list. In the name of my grandfather, Jainuddin.
No, but what is the
Yes.
document to show that he is the grandfather? Because you can get
No, then
voters
I
list
am
of
coming.
anybody.
No, that is in written statement, that is Jainuddin is my grandfather. Page 17 is the 66 voter list. 71 is also. Then Julhas Ali is my father. Page 21. Julhas Ali's father's name is Jainuddin. It is written. And my name is Muqsad Ali. My father is Julhas Ali. So there is linkage.
No, you see at page 13, the finding is there of the tribunal. Last part of first paragraph, page 13. In this IA. But there are two different persons, Jainuddin and Jayanuddin Ali.
It is not correct, my lord.
We
It is
don't know
not
because
correct. Because
I've been asking this question because in my till now my name has never been changed. The last 30 years I am looking at you. I have never found that you have been called by any other name. How does only name of the proceeding changes?
the name is
Their father's name change. Jainuddin becomes Jainuddin Ali. That doesn't happen.
No, let me satisfy your lordship. Only see page.
Can you get the information by Wednesday or Friday about the health condition?
Yes, Friday.
Page 11, the documents list. Perhaps he can take just now also.
No, that's not possible.
It's not easy because they don't
Yes,
have
ma'am.
direct contact
Yes.
with the transit camp.
Yes.
They'll only have to request the superintendent of
Aspect of
police
that.
and thereafter the
Yes.
information will come. So they have no access to them.
Friday, 29th.
Friday. And this is a document, Mr. Mahmood, please give Mr. Payang a better copy of page 17. It will be easier for him to take instructions.
Yes.
Yes, there is no such doubtful matter. May be wrong, there may be anomalies in names.
No. Page 17 of the IA. Give a better copy to him, Mr. Payang.
Yes,
It will be easier for him to get information.
Yes, he can take. He can take.
Get a better copy. Give a
Yes,
better copy of this to him.
Yes, I.
No.
Only this, only this.
Mr. M.U. Mahmood, learned counsel for the applicant submits that the applicant is not keeping good health. The petitioner, namely Muhammad Maqsid Ali, alias Maqsid Ali, alias Naskat Ali, who has been apprehended on 22/7/2024 and currently lodged in transit camp Matia, Gwalpara, is not keeping good health. And in this regard, it places reliance on a discharge slip dated 24/9. What is the date here?
Date is, my lord, 19/9/24, date of admission.
No, the signature, MO signature.
MO signature that is not visible, indistinct, my lord. It will be perhaps 24/9/24.
Medical certificate, discharge slip within bracket page 17 of the IA. Next para. All the respondents are represented. Next para, the learned counsel for the petitioner the applicant shall provide a better copy of page 17 of the IA to Mr. J. Payang, learned standing counsel for the FT matters, just to enable him to obtain information about the status of health of the applicant. That was the discharge slip, bearing indoor registration number 2350/24.
Thereafter, my lord, he was also brought to medical college.
Okay.
Medical College of Guwahati. From there he was certain days, but he needs operation. So again he was taken back.
Including current health status. As well as information as to the reason for the petitioner's admission in the civil hospital Gwalpara on 19/9/2024. Next one. Mr. Pang, you have to say that you will use the office of the jurisdictional police station.
Yes, ma'am.
My lord, may I pray one thing? Thereafter, he was brought to Guwahati Medical College.
It's okay, current status we are asking, so everything will come. Next one, the learned standing counsel for the FT matters is permitted to route is for communication through the jurisdictional police station and of the God, the jurisdictional superintendent of police, in the bracket border. Mongolday,
Yes.
sir.
Yes. Dorong.
No, he's lodged in this page 17 is in Gwalpara. That's why I'm asking you. The page 17 is at Gwalpara.
Yes, ma'am.
So
No,
you
that
will
is
get it
his-
from Gwalpara, Superintendent of Police
My
border.
lord, SP Mongoldo, because they have to record with them.
They have the records. Okay. SP Mongolday,
SP Dorong Mongoldo.
Dorong Mongolday. Next para list on 29/11/2024.
All right.
Item 17 with 18 for admission.
Putin, what was the deliberation on the previous date?
Yes, my lord. One yellow color flag mark, my lord, as per direction of the SP, my lord.
Record with them.
In this case, my lord, two brothers, my lord, Moinul and Nurul, my lord. And two cases registered each against each other, my lord. And subsequently, my lord, as per direction of the SP, my lord, and the inspector of border, my lord, inquired the matter, my lord. And in the inquiry report, my lord, kindly see yellow flag, my lord. Moreover, my lord, in this case, my lord, petitioner mother reduced as DW3, my lord, and paternal uncle as a DW2, my lord. But tribunal did not given any finding, my lord. DW1, 2, and 3, my lord.
In the written statement, you have introduced your uncle.
Yes.
It's not, his name is not there. Your father's family is, history is not given there.
And in the voter list of 1997, Miller, both the petitioner's name appear along with the mother. And mother name appear in the voter list of 1965, 70, and also in the sale deed, Miller, purchase deed in the 1965. Same village.
Which record we should see first, to 227 or 229?
Yes.
229, huh?
Moinul.
Moinul.
Yes. A common order.
But
Common
records are
order.
different, that's why we're asking you which record we should see.
Only one record.
This evidence of Moinul Haq doesn't take him anywhere. It does not even give the name of the mother and father.
In the written statement, my lord, mother name, father name is.
No, I'm reading the DW. He is DW1. It does not say anything. Mata Pita naam ase. No, who's the mother and who's the father? It doesn't say that. Correct.
Moinul, Okalatnam.
Yes. No. Wakalatnama we did not put any
Yes,
flag.
yes,
Ah.
like a written statement.
No. Second flag.
Second.
What is this?
Sarkar Bonam Moinul House.
Hapatnama. Correct. This is dated 26/6.
বিদেকে গোচৰ মই আৰু লগত মোৰ ভাইকৰ মাজত ঘটনা নিৰ্দিষ্ট বিভাগৰ ওপৰত উল্লেখ গোচৰ সম্পূৰ্ণ মিছা ওপৰত হৈছে উক্ত গোচৰ সম্পূৰ্ণ মিছা মোৰ ভাই ককাইৰ জন্ম মোহৰাংজান পথাৰ অন্তৰ্গত পথাৰ গাঁও মই মোৰ ভাই আৰু ইয়াত
No point reading it. We just tell you. What is the date of this evidence?
evidence
26/6.
yes 26/6/2015
15.
yes.
Now second flag, the third flag. This is another evidence on affidavit by DW1, same person,
Yes,
correct?
yes.
Now look at the order sheet of 26/6.
Here is 18/7/2016.
16, yes. Look at the order sheet.
Twenty-six.
26/6 order sheet.
OP appears and filed written evidence without document.
Hmm.
Fixed on 37/2015 for cross evidence of the
Yes.
OP.
Now the other evidence is not even accepted. Second flag, third flag, that is not even accepted. And there was no document. In cricket, there can be two options. One is a bouncer, one is a sixer.
Miller, here is last base exhibit 5, voter list 1966 exhibit.
But everything is gone. What has happened is the tribunal, without accepting the evidence, inadvertently started the examination and in the back page of the third flag.
Yeah.
So he's under the impression everything is okay, does not consult the records.
Yes, he mentioned Miller, exhibit 1 is the certified copy of the voter list.
But
of
that goes,
60.
evidence is the only evidence where there is no document.
Documents,
Everything is washed away.
here is exhibit.
Motin, see the order sheet, whether there was any order on 26/7/2015.
No.
So it is merely
26
unauthorized document on record.
Is there any order?
18.
18/7, yes, 18/7 order is there.
18/7.
Whether there is any order on 26/7.
18/7, 16.
There is no acceptance of the second affidavit. There cannot be two evidence unless one is expunged. The second evidence just cannot exist.
There is no 18/7, no? 18/7, there is no any order. (12/5/17) 12/7.
14-9, 17-11.
And you see,
This is the procedure.
now all other cases go because you come back to the second flag. This is a common evidence in 5 cases. In the left side, you will find the case numbers. No, first page of that flag.
Yes.
So each and every case of yours goes. You don't have anything.
So many cases registered in the different name. Father name
That's
is
okay, but all 5 cases go. You file an evidence without documents. End of the matter.
subsequently may be exhibited. Here is as per
maybe-
then evidence
No.
Here is written.
Maybe, you see-
Padarkhok 1, Padarkhok 2.
Mr. Ahmed, maybe is a word which is in a trial court, it appears foreign to us. There's nothing called maybe, might be, could be. In the trial court, it cannot be. Trial court is only yes or no.
Subsequently exhibited. Here is original certified copy of the voter list, etc.
You have some experience.
I have no experience, my lord. I'm not going to that.
What happens if the evidence is like that?
Actually, my lord, this is the procedural lapse of the.
No, but the difficulty is that you see, except
Otherwise,
for
my lord,
except for
on
us,
the other hand, my lord, petition established linkage.
no, the sad part is that except for the bench, nobody wants to care. Nobody cares to go through the trial court records. That is the difficulty. But in trial court, unless the evidence is comes on record and not expunged, that stays. The second evidence will have to be brought in. It can't be by default.
Mr. Motin,
No.
what my esteemed brother is saying, that in a writ petition, suppose you are a respondent,
Yes.
right? You have filed already an affidavit in opposition, right?
Right.
Then after 10 days, you cannot file another affidavit in opposition without recalling the earlier affidavit in opposition.
No, my lord. Dear
So
my
here is a case where you have already filed an
Yes.
affidavit, affidavit.
evidence.
And without recalling or without any order,
Yes.
on a day when the tribunal was not sitting, you file another affidavit on 26/7/2015, where there was no order, right?
Yes.
Accepting the evidence on affidavit. So there is no order recalling the earlier evidence on affidavit.
And this is the
So the second affidavit is not to be accepted. Your case will be entirely based on first affidavit, where there was no document.
but here is mention, my lord.
Mention.
Yes, Padarkhok 1, Mono
No,
Namak
you
Diya
have to-
Sarkari.
No, Mr. Motin,
As per order.
there is a proverb.
As per order, my lord, there is no document.
মাথার আছে খাতার নাই।
Yes. Yes. Absolutely. Absolutely.
That's why I said.
And tribunal also accepted this subsequent evidence, my lord, and cross.
No, unless you expunge, we can't take
The
because
procedural lapse, my lord.
we are exercising.
Procedural lapse. I am saying.
This is evidence, not procedural lapse.
I don't.
No, unless you can convince us, we still have the same opinion that there's no case at all. Unless you can make a very good argument.
And my lord, in the inquiry report, my lord, previously, my lord, 2 cases, my lord,
But
inquired by
inquiry,
the
you see, there are a lot of judgments which says that inquiry is merely a starter. It doesn't have any evidentiary value.
But as per Supreme Court Milot, Abdur Rahim case Milot, 33, 30, 34, 35, and 33 Milot, there is specifically stated that there must be source of doubt, there's a source of Milot information.
No, once you,
But in
once
this
you see,
statement,
once
I
you
have
can't
seen my lord,
establish.
there is no source of
No,
doubt.
once you can't establish, there's a sort of doubt in the written statement. Look at the written statement. You don't show the relationship. In their evidence on affidavit, you don't state about anything. You just come from the first paragraph. You come to the documents. You don't even introduce the. You don't even support your written statement.
Only written, my father name is so and so, mother name is so.
No, that is also not there.
Yeah.
Look at
Yes,
it. My father's name
Yes,
appears in
yes.
voters list of so and so.
And in the written statement, Milot.
So even the statement made in the written statement is not accepted in the evidence on affidavit. Interlocutory facts are even not proved.
Facts is proved by the mother Milot.
Then
Mother name is
That
appeared
can't be.
along with the petitioner.
your supporting witness can't give a better evidence than you.
And mother is the best witness.
No, she may be a supporting witness now. The best witness would only be the proceeding. Mother is a supporting. She may be a star witness, but she's only a supporting witness. Best evidence must be tendered by you. You are the proceeding. You are required to prove the link.
The link is proved in the voter list of 1997. The mother name is appeared 1963 along with the father Milot.
No, but that lady is your mother. There's no evidence at all. Read into your evidence. That the lady produced by you as a witness is your mother. That also not stated anywhere.
In the written statement, Milot.
No, evidence is there. You look at the evidence. Written statement is overridden by evidence. Read your evidence.
Evidence part is not clear, Milot. Otherwise, Milot, in the written
You
statement,
don't
Milot,
introduce the names. That is the
the
difference.
petitioner stated.
Difficulty is that you don't introduce names. Marty Petrie. Naam iman voter list or ase.
Yes.
Of remand. The reason is, look at the evidence. Mr. I think this give him is the record. We have the second flag is the only evidence.
Yes.
Correct. We have sent you both records. In the second evidence, in the second record, no, that is the first record. Number one is there are 5 cases there.
Yes.
He's DW1, right?
Yes.
Without documents. Now look at the second record. DW1 is not there.
In the WS money.
WS is there. DW1 we could not find it. Perhaps we could not see it in a better way.
The reference is different.
Inquiry different, data different, 4 case, 5 case.
Records,
Only these two cases, madam.
these two cases is of 6 cases, is a, out of 6 cases, only,
Out of 6 cases, only 2 cases.
there are only
My
2.
lord, in fact, the notice 662 was sent to the petitioner, only 662. In fact, he should not have mentioned all others cases numbers because his case is against 662, my lord.
Application
petitioner's case.
2015.
And the
Application
next
29.
record is of my lord, the Nurul Haq.
Nurul Haq, that is
Nurul Haq is a different.
2715.
Yes.
No, 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 that-
Now, see, we're asking you this question because these people,
Why he has mentioned the my lord, numbers of cases, I don't know. The when filing. the-
maybe they are same family
Come
members.
to the judgment, page
Yes,
40,
probably for
Page
that
40,
reason.
all 4 are taken together, all 5.
all 6.
6.
Yes.
So there are 6 reference.
There are 6 references, different references
Now.
of the
you
same
see,
family.
If a particular written statement is filed, sorry, this evidence in affidavit is filed.
Yes.
Now look at the record of the second case. How does he say DW1 tribunal? How does the tribunal refer to the evidence of DW1?
Same DW
26.6.
proceeding are different. DW1 will be different.
Evidence.
Evidence of DW.
Yes, yes, that's I'm looking, my lord. WS filed separately.
WC is separate, but
Yes.
DW1 I did not find. But I did
I
not
think
check.
there is one common DW,
Probably.
Muhammad Samiruddin, their uncle, and DW2, mother Habibun Nessa, maybe common.
No, mothers, DW2 will let see.
Wait, Habibun Nessa.
DW2 is separate.
DW2 is separate.
What is the name of DW2?
Habibun Nisa.
Habibun Nessa.
Habibun
Habibun
Nisa.
Nessa. So DW2 is different, only one is same.
No, Habibun Nessa is only mother, because he is proceeding number 1, page 40,000. If page 40 आपको how page 40 saw.
Nazrul Islam is the same person or different persons?
Miller, as per notice Miller, page 38 and 39 Miller.
No, they are your clients. Don't go by notice. What is your instructions? They are same persons or different persons?
All are brothers Miller.
By the same name.
No, here is my lot Moinul,
Nurul Haq and Nurul Haq, two brothers.
Moinul, Nurul, Azizul.
Please read. Moinul. First
Miller-
read page 40.
Yes. Nurul Haq,
Okay.
as a Nuzrul,
Yes.
Moinul,
Yes.
Azizul.
Yes.
And the next page Miller to Moinul Haq and Nurul Haq.
Huh.
So same.
So, serial
All
number
are
1,
brothers.
Nurul Haq, and serial number 6, Nurul Haq.
Yes.
Two brothers by the same name.
Nurul Haq. Say Nurul Haq. Here is the brother Miller.
Brother, Nurul Haq.
Yes. And Nurul Haq and Nurul Haq, 1 Miller, Moinul 1 and Nuzrul
that's what
and
we are
Azizul 1.
We are asking for your explanation.
Minute.
Because there may be 6 brothers and four of them are
Yes,
resigned.
one and same person. One and same person. Page 40 and page 41 Miller.
Where is
Same
the
person.
judgment there? You are preferring which one?
I am here is a Moinul.
Hmm?
Moinul, WPC 5740.
Only one.
Yes.
But the other will remain, other
I
judgment
mean,
will remain,
I-
that
I-
declared
another
to
is
be
a
foreigners.
Yeah.
Another, next is Nurul, no? Next one is Nurul.
Both Mr. Motin, Habibun might have difficulty in calling her two sons by Nurul and Nurul. Nurul 1 and Nurul 2. Moinul 1 and Moinul 2. Hmm?
Yes, for inquiry report Miller, there is no Nazrul Miller.
Mr. Motin,
Miller.
Habibun has
A mother.
how many sons?
In my petition.
This is a case of designer baby. One does the crime and the second will say that, oh, no, I am here. I did not commit that crime. Same name.
Alibi.
Good case for alibi.
Instruction to assign instruction set. Each one of the other instruction.
And where are the other cases of this, all this reference? There are 6 people. Which are the writ petitions for them?
Next one is another one, but that is
Brother.
Nurul.
That's okay, 2.
Yes.
What about 6? There are 6.
He is Moinul. He has another brother by the name of Moinul. From the same mother.
So we are only asking that there are 6 opinion.
First and last Nurul is same person.
No, we don't know. There are 6 opinion.
Here is the record. In record, I have found it.
No, Mr. Pang, come to page 44 now.
Yes.
Read the first line. Parties, namely,
Nurul Haq,
son of Mosaid Ali,
Musaid Ali,
Muhammad Nazrul Islam, son of late Mozaid Ali, Muhammad Moinul Haq, son of Mozaid Ali, Muhammad Azizul Haq, son of Mozaid Ali, then Muhammad Moinul Haq, son of
that Aklumia.
Aklumia.
Aklu korba ahila.
Aklu is the father name of Moinul. Moinul and Nurul.
So that means they are different persons.
Different persons.
If there are 6 reference answered, there must be 6 writ petitions.
Reference to is
So, Mr. Motin, you are for whom? Son of Aklu or son of Mozaid?
Aklu.
Yes, son for Aklu.
Mother is same.
Same.
Habibun Nisa.
Habibun Nisa. 100%.
Not possible for human mind. Habibun Nisa is saying both are all our sons. Both Nurul, both Mainul. Then her husband would become Aklu as well as Mozaid. Huh?
Whatever is written there is correct. View is that can we do what the tribunal has done? We pass an order and then you go wherever you want to get it corrected.
No, I don't think. What my understanding is that the initial record.
No, but you see,
Yes.
now, you see, we are in a situation where except for passing few smiles, we can't do anything. Now, Mr. Sharma says that as per the record, these two people are same. But it can't be. It's nobody's
Can-
case that
yes,
Aklumi
yes.
and that so-and-so
no.
are same.
No, my lord.
So
It
there
is
are two different
now,
fathers.
now they are claiming, my lord.
Now, Mr. One more,
They are claiming.
fine.
Yes.
Come to page 44 again. Okay,
Yes.
you read the name of Azizul Haq, son of
Late Musaid Ali.
Yes. Nurul Islam, Nurul Haq.
no,
son
no,
of Muhammad
Azizul
Ali.
Haq. Just another example, Azizul Haq,
Azizul
son
Haq.
of
Mosaid Ali.
Mosaid Ali.
Yes.
Come to page 35. Read the first name. Page 35.
Barnacular petition.
Vernacular.
Page 36.
Azizul Haq,
Yes.
Aklumi.
son of,
Aklumia.
again read page 44. He is son of Mosaid Ali.
Mosaid Ali.
No,
So
perhaps that is why they, both of them did not read the records.
No, no, my lord.
Good.
What my understanding is, my lord, while inquiring the matter, because this is only one, my lord, the inquiry report of the only one case, my lord. While inquiring the matter, the and only names, my lord, the father's name has been shown as Mosaid Ali. While filing WS, they are saying, my lord, they are son of my lord Aklumia.
No, but that is okay.
Now
first
their
is-
case is that they are son of Aklumia.
No, now that's why you see, once these are the difference in the names.
Yes.
And then there is only one DW, which the tribunal has accepted.
Yes.
Despite there being 4 cases, he accepted the only one evidence for DW1. Is it?
Other cases we don't know, my lord, because other cases are not before us, because
That's why we are asking, what are the petitions against those challenges? You find it out, otherwise there'll be conflict of opinions.
yes, madam. Then, my lord, whether they have approached the honorable court or not, that is also not known, because they may not approach. Once declared, my lord, they will abscond. Sometimes they do not approach.
No, but try to find it out.
Yes, I can find, my lord, try, but I'm not sure whether if they are approaching the honorable court, my lord, I'll get it. Otherwise, I can ask for from the tribunal if, my lord, the cases are, the records are available of these cases, other cases or not. Then I can call, if your lordship direct me, I can call
Because
for the
otherwise
record.
there'll be conflict of opinions.
Yes,
There will be different judicial pronouncements.
Yes, my lord. If your lordship direct, my lord, the entire records of all these cases is called, my lord, irrespective of registry filing cases or not, then I can, my lord, bring the records. If there is no case pending in this honorable court also.
Everything is confusing.
Yes, my lord.
Azizul Haq, son of Mosaid Ali, he becomes Azizul Haq, son of Aklumia.
No, my lord, that's why, my lord, what this kind of cases are, my lord, while making inquiry, they do not give the proper names, my lord. That is the problem, because to evade somehow from the, my lord, proceeding, sometimes they give a wrong name. But in inquiry, it is ascertained. Now, my lord, it may be that in some cases, my lord, I'm not generalizing. My lord, in some cases, when they find that there is a documents in the name of my lord Azizul Haq, son of Akulmia, they may claim that I'm the son of Akulmia. That's why, my lord, it is very necessary at the time of WS, filing WS, that each and everything should be given properly. Otherwise, they may take, my lord, the advantage of some other documents. That's why, my lord, because in my lord, enter evidence, enter, my lord, inquiry, it is my lord Asad Ali. Musad Ali. In the own, my lord, while making inquiry, police inquiry.
That's why again speak the correct.
Not sure, it appears.
Yes.
It appears.
Yes, all sides are represented.
Tribunal into their mother. But I cannot be sent with their mother.
On a perusal of the common opinion dated 29/6/2017. The court takes note of the fact that he said cases are as follows. Page 40. Huh? Number one, there are 6 cases. Number one, FT/L, case number 227/2015. State versus Mohammed MD, Nurul, NURUL, Hawk, HOQUE. Just quote it from here. Huh?
1, 2,
Yes,
3, 4, 5,
6,
6.
1, 2, 3, 4, 5, 6.
44,
In the page number?
Page 44. এইটা ছয়টা।
Mother of sons.
They are mother.
Phone number আছে না?
42, 6 para 6. এইটো তাৰপিছত লিখিব। এইটো যে হেৰি হৈছে বুলি
In paragraph 14 of the said opinion, it is recorded as follows. Page 43. Last line, huh? Page 43. Okay. You see, paragraph 14 of the said opinion is quoted below. Paragraph 14 is at page 43.
Paragraph 6.
Next paragraph. It is also noted that in paragraph 6 of the said opinion, it has been stated as follows. Quote para 6, page 42. Next paragraph. Therefore, no, not therefore. From the above quoted paragraphs of the impugned opinion, although there is reference to the names of fathers of the proceeding as late Mosaid Ali, MOSAID Ali, son of late Aklu AKLU, Mia MIYA.
No, Mosaid Ali or Aklu Mia similar fathers.
Tinta father, eta mother.
Duta father. Father is 2.
Father is 2.
Father is
So
2.
and so, but the 6 proceedings have a common mother, namely Habibun, HABIBUN, Nessa, NESSA. Full stop. Next paragraph. It is also noted that it's also noted from the records of the learned tribunal that a common DW1, the common evidence on affidavit by DW1, namely, what is the name? The second flag. Nurul Haq, Moinul Haq, namely Moinul Haq, MOINU, MD, Moinul, MOINUL, Haq, HOQE, had given evidence, although he is the proceeding in FT/L/case number 229/15 and FT/L/case number 233/2015. Sorry, 15, only 15. Next paragraph. Therefore, comma, in order to avoid conflicting opinions, comma, the court is inclined to call upon the Mr. J. Panek and standing counsel for the FT matters to get information about the records of all the references in which common opinion dated 29/6/2017 was given by the learned Foreigners Tribunal, comma, Nagaon, court number 7th, comma, Lanka. No, just say Foreigners Tribunal, Nagaon 7th at Lanka, comma, Hojai. Full stop. Moreover, comma, next para, moreover, comma, if it is possible, comma, to ascertain as to whether separate writ petitions have been filed in respect of all the 6 FT cases referred to, comma, referred to in the common opinion dated 29/6/2017. Next paragraph, the learned standing counsel for the FT matters is permitted to send a downloaded copy of this order to the jurisdictional superintendent of police within bracket border bracket close Nagaon, as well as to the Foreigners Tribunal, Nagaon 7th, comma, Nagaon at Lanka, to obtain requisite information. Next para list after 2 weeks. Okay. Next para, food less 2 weeks. In view of the discrepancies referred above, comma, the Mr. J. Pang, learned standing counsel for the FT matters, has requested and has prayed to allow him access to the tribunal's records for perusal and doing the needful stuff. The courtmaster may permit the learned standing counsel for the FT matters to have custody of the said 2 records of FT case number 229/15 and FT case number 233 of 2015. For records. In 2 files, there are 4 records, two records each. In 2 files of 2 records each. Total 4 records. List for 2 weeks. We'll rise with a single bench. Mr. DP Goswami and APP for the state. Next, the learned counsel for the petitioner has submitted that the bail application of a co-accused was rejected by this court by order dated 28/5/2024 in BA 1242 of 2024 dash Ahmad AMAD, next word Uddin UDDIN, third word Tapadar TAPADAR versus State of Assam. Full stop. It is also submitted that in connection with this said bail application, comma, the status of trial as on 19/4/2024 was available. Full stop. Next, accordingly, let the records of BA 1242 of 2024, along with the scanned copy of records available therein, be tagged with this record. Next para. The registry shall send a requisition for scanned copies of the trial court record on and from 3/5/2024 up to date. Next para. The registry shall send a requisition through email to the Court of Additional District and no, this will be Special Judge Karimganj. Special Judge Karimganj in connection in respect of special within bracket NDPS bracket close case number 155 of 2022, comma, arising out of Karimganj PS case number 588 of 2022. Comma, for the scanned copy of the records of said case on and from 3/5/2024. This last paragraph, you correct it, huh? I've said twice. There's a repetition. Next paragraph. In the meantime, you should notice on the state to the granted APB, which is made returnable on, give after 10 days date. List on so and so.
9th of December.
Item 2,
Yes, anything has come up? What does it say? No, you see, we have told you last time also, this leads to many difficulties and this is contrary to the judicial discipline. Because there are not only orders of this court, but also Supreme Court, where it says that the process of recruitment comes to an end after the results are declared. Now, if you are saying this, you'll have to file an affidavit because this is something which the court of its own, on the strength of your communication, cannot pass an order. Mr. Chaudhary, am I right?
They have taken the stand. They said people ready to accept diploma of civil engineering and planning as equivalent.
No, if they take a stand, they can take a decision itself, and then why leave it to the court? Because there are difficulties.
They can see they make their position very clear. 40 out of 290 who were recommended were not appointed, and 31 out of those appointed did not join. So effectively 7.
Here there are two views subject to correction. Number one, you see, if there is if a particular subject is an equivalent, that must be made known at the time of commencement of the recruitment process, because there may be several persons who are left out and they may not have done the litigation. So supposing you think independently, not for this brief, but if you think independently, then judicial conscience says that this is not permissible otherwise. I think so, because for the court to take a decision will be negative. That will harm Mr. Chaudhary more. It's just and the second question is, you see, if they say that there is a vacancy available, so whether that can now be filled up and whether the process does not come to an end, that is the second question which we have to determine.
Whether civil engineering and planning is equivalent.
Correct.
Or there is a judgment of this court, it is. That it may not pose any difficulty. Because this honorable court has already, other coordinate bench has already held that it is same.
It is equivalent.
ACT also says, my lord. It was only APSC who brought out the issue. And my lord, a coordinate
You
bench
bring
of
in
the-
an affidavit, then it settles the matter.
The other judgment, my lord, a coordinate bench of the honorable court has already said.
No, I think that was placed.
And secondly, my lord,
Mr.
Indian Council for Technical Education, which is the model agency as prescribed under the Constitution, my lord, that has also said that it includes.
Then if
And
the
even
affidavit,
Directorate of Technical Education, Assam has also clarified that.
then if that affidavit comes, it becomes easier to accept the coordinate bench judgment and then follow it.
Yes.
Do it within a week,
Yes.
10 days time. So 9th of December. All sides, including Mr. K. N. Chaudhary, learned senior counsel for respondent numbers 1 to 3 are present. Next paragraph, Mr. N. Upadhyay, learned standing counsel for the irrigation department, has submitted that he has received a written communication dated 25/11/2024 regarding the vacancy position, as well as that the department is ready to accept the diploma of civil engineering and planning as equivalent to the required qualification for appointment in the post of junior engineer within bracket civil. Next paragraph, if that be so, let an affidavit be filed by the concerned authorities of the competent authority in the irrigation department to bring that stand on record. Next paragraph, the learned standing counsel for the irrigation department prays for some time. Prayer is allowed. List on 9/11/2024, 9/12/2024, post of the proposed affidavit shall be filed at least 2 days prior to the next date of listing. Pardon me? Oh, okay. The copy of the said communication dated 25/11/2024 is retained on record. Next paragraph, the interim order passed earlier stands extended till the next date of listing.
Item 3,
Yes, Mr. Chaudhary, you have instructions in the matter? But you have to, because the coordinate bench has already passed an order, I think. This, because then it would be, I think a coordinate bench has accepted this and has accepted the challenge. How much time? Yeah, do it. I request your authorities to give it early. Huh? No, there are other matters also. Okay, here I issue notice returnable on 9th, 9/12. Okay. It is heard Mr. Askiroyd and counsel for the petitioner. Also heard. So the state will be there. Respondent number one. Mr. Dinath, okay. Mr. Dinath, senior committee advocate, appearing for respondent number 1 and 2. And Mr. Sharma, you are appearing for 3. And Mr. C. Sharma, Learned standing counsel for respondent number 3. Health, you are there. 3's. Huh? Acha, Mr. D. Upamanya, Learned standing counsel for the health department. Representing respondent number 4. 4, 7, and 8. And Mr. I. Bhattakur, Learned standing counsel for the forest department, representing respondent number 5. And Mr. V. Chaudhary, Vikram V. Chaudhary, Learned standing counsel for the SLRC, representing respondent number 6. Next, brother. The issue notice on this review petition returnable on 9/12/2024. So requisite extra copies of the petition, review petition be served on the Learned State and Departmental Council within 2 days. Next, para. The respondents will be ready with their instructions on the next date of listing. Next, para list on 9/12/2024. Pardon me? No, then we are saying in the week commencing 9th year of difficulty. But then last week it has been very difficult to take up these matters. Because before vacation, you know the pressure we are having. Then we make it first week of January. This in the first week of January on a date to be fixed by the registry.
Item 4.
And returnable date, make it then first week of January. This is 2 items, 3. Yes. Page. Hey, just a moment. Page 90. Where is the order of the court? Page 17. Yes, why you file a review? No, but still you'll have to pay, even if you're not there, what is the incorrect in the order? This, that's a ground. You see, now we have an order of the Supreme Court saying that the assets be sold off. Then, yeah, other persons come because this is not a case for review. What is wrong in the order? Page 94. No, Mr. Rashikar, but still, you see, whatever has happened, the fact is that this order does not require any modification. No, you see, not only this court, but Supreme Court of India has also said that this retirement dues is not a bounty. So you can't make payment of this in installments. There's not one, there are many authorities on the point. No, it has to be in full. No question of major or minor. No, Mr. Rashekar, you see, it's example, I have given you an example. My examples are always horrible. One of the worst examples you see, you go to the street for some street food. Let us say a cup of tea. The shop owner says that my tea is priced at 10 rupees. Now you say that I have 9 rupees. So is it a good compensation for a 10 rupee tea? So that 1 rupee may not entitle you for even a 9 rupees cup of tea. Because if the shop has a price of 10 rupees, he said 9 rupees, I don't sell tea. But why should we entertain? Why should we issue notice at all? This is a arrear pay of what period? Is 17 you said. No, no, the dues.
On monthly basis at the rate of 10,000 per month. Each and every repaired process. And so the only the residual amount has been paid. They automatically pay the residual amount months payment to the sort of effect. Processing only. Now they are paying the amounts to 4 or 5% in a month. 3 months means of the dues will be over.
Doesn't inspire confidence. No, those are all grounds. You give a letter, you don't pay the lawyer, why should he appear in the first place? This, I have read that complaint. You have not said that we made the advance payment and then the advocate did not appear. No, that's okay. In one case, we don't get the fees. Why should a lawyer appear in the first place? No, Mr. Rashekar, we are not entertaining this. Just give you 4 weeks more time to make payment. Just because you have filed the review petition. No, it is, there is only 4 months we have given you from 6. So 6. 2 months to examine. And then 4 weeks, so 6 months, 6, 6, 12. You already have 1 month. Make payment. No, we record your statement, but we are not entertaining. Heard Mr. Rashekar, I will counsel for the petitioner. No, but you already have 1 month's time till end of. We are proposing to give a 1 month's time. That 1 month time you already have. No, no. You already have that. Mr. Rashekar and counsel for the petitioner. By filing this application for review. No, sorry, this application for review is directed against the order dated 26/6/2024, passed by this court in WPC 840 of 2024. Next para. By this. No, not the next paragraph. In WPC 840 of 2024, the case projected by the respondents, who are the rate petitioners in the said rate petition, was that they had retired from service under the petitioner corporation, while retirement notices as more fully referred in paragraph 4 of the said order dated 26/6/2024. And that the petitioner's CPF, gratuity and leave encashment were not paid. Full stop. The proceedings of WPC 840 of 2024, the petitioner remained unrepresented. And accordingly, the court was inclined to dispose of the writ petition by directing the respondents herein to submit a fresh representation to the chairman, Assam State Warehousing Corporation, along with a certified copy of this said order dated 26/6/2024, describing the nature of their claim and it was also provided that in the event the respondents herein have any other claim, it would be open to them to submit a fresh representation, quantifying the nature of claim, if any, full stop. Next, accordingly, the Assam State Warehousing Corporation i.e. the petitioner herein sorry, the petitioner and the chairman of the petitioner corporation were directed that on receipt of a representation from the respondents herein, they would examine the claim of the respondents within a period of 8, within bracket in words 8 weeks from the date of receipt of a certified copy of the order, along with the representation First of it was further provided that if any amount is found due and payable to the respondents herein on account of CPF, gratuity and leave encashment, steps shall be taken to disburse such amount within 4 months thereafter. First of, accordingly, the writ petition was disposed of. Next paragraph. The learned counsel for the review petitioner has submitted that the respondent corporation is in a very bad, sorry, the petitioner corporation is in a very bad financial position. And it is submitted that during this financial distress period, many personnel serving with the petitioner corporation have superannuated. Full stop. It is submitted that although that as the review petitioner is not covered under the Assam Service Pension Rules, 1964, the petitioner corporation is making payment to all the retired personnel in installments and on pro rata basis. Accordingly, it is submitted that if the claim of the respondents herein is required to be paid in a time-bound manner, as provided by the order dated 26/6/2024, passed by this court in WPC 840 of 2024, the entire money that may be available with the petitioner corporation would be taken up in paying the dues of the respondents, and there would be no amount left for disbursing to the other retired public superannuated employees. Next paragraph. It is also submitted that the default in appearance of the petitioner in the proceedings of WPC 840 of 2024 was not deliberate because the petitioner corporation had appointed a counsel and he was requested to take steps in the matter on receipt of notice of the proceedings of WPC 840 of 2024. However, the learned counsel, engaged by the petitioner corporation did not appear and take steps in the said writ proceedings. But rather, give an opinion. Which page was that opinion? Given opinion. While advocate's letter dated 2/8/2024 Full stop. It is submitted that due to non-appearance of their engaged counsel, the review petitioner has preferred a complaint before the Bar Council of Assam, Nagaland, etc. By paying the requisite fees on 27/9/2024. Next paragraph. It is submitted that the non-appearance of the petitioner was not willful, and therefore the petitioner corporation be afforded an opportunity to contest the proceedings of WPC 840 of 2024. By filing their affidavit in opposition in the said writ proceedings. Next. In the present case in hand, the respondents had superannuated or retired from service under the Assam State Warehousing Corporation. And as per the order under review, the respondents herein had filed the writ petition claiming non-payment of CPF, gratuity, and leave encashment. Huh? In this said context, the learned counsel for the review petitioner has submitted that CPF dues has already been paid in full to the petitioners. Huh? So it is also submitted that major part of the leave encashment has also been paid to the petitioners in installments. Full stop. Next para. By order dated 26/6/2024, passed in WPC 840 of 2024. The court had made it clear that the respondents herein would make representation before the petitioner corporation and its chairman, and they were granted 8 weeks time from the date of furnishing of a certified copy of the order to examine the claim, and thereafter 4 months time was granted to disburse the dues. Next paragraph. Yes. It is not the case of the review petitioner that no amount at all was due to be paid to the respondents on account of their superannuation, public retirement from service under the petitioner corporation. Full stop. It is too well settled that retirement dues payable to a superannuating employee is not a bounty. And the dues like CPF, if any, gratuity, if any, and leave encashment, if any, is lying in the lying payable for the superintending employee. Is by dint of its accrual in course of service. First, under the circumstances, as the court has already granted 8 weeks time from the date of 8 weeks time to the petitioner to examine the claim of the respondents herein from the date of receipt of certified copy of the order. And as 4 months time has been granted, thereafter to the petitioners to disburse the unpaid CPF, gratuity and leave encashment, if any, and to take steps to disburse such amount within 4 months thereafter. So accordingly, from on and from 26/6/2024, about 6 months time has been granted to the petitioners to make payment of the retired dues of the petitioners in form of CPF, if any, gratuity, if any, and leave encashment, if any. Full stop. Under such circumstances, the court is of the considered opinion, as there is no error apparent on the face of the record in connection with the said order dated 26/6/2024, passed in WBC 840 of 2024. No case has been made out for exercising review jurisdiction of this court. First, accordingly, court does not find there to be any good grounds for exercising review jurisdiction for and for interfering with the order dated 26/6/2024, passed in WBC 840 of 2024. Next, it may be reiterated that in this review petition, it is not the projected case of the review petitioner that no amount at all is due and payable to the petitioners on account of liabilities like statutory liabilities like CPF, gratuity and leave encashment, or to the extent payable after adjustment of payments already released so far. Next paragraph. Merely because the petitioner corporation is making delayed payment of such dues to others, in the absence of any agreement between the petitioner corporation and the respondents herein for a deferred payment of the retiral dues. Payment of such dues in installments to others would not be a good ground for entertaining a review petition. So according to this review petition stands, it is not entertained and the same is closed. Without issuance of notice on the respondents.
Item 5.
Pardon me, I did not get it. Okay, you wanted adjournment. Okay. On the prayer made by Mr. I. Bothakot and at council appearing on behalf of the Standing Council for PHE, the matter stands adjourned today. Rest in the next week on a date to be fixed by the registry. Since I'm in division bench, they'll have to fix it someday.
मुन्ना भाई फिर वो कहानी याद आई जिंदगी में वो कैसा है ডেটটো মানে নিদিয়ে এই স্যাৰে তাকে ক'লে আমি পঠাই দিম যেতিয়া এখন সিঙ্গল বেঞ্চ বহিব তেতিয়া স্যাৰে মানে ৰেজিষ্ট্ৰিয়ে বাকি সিঙ্গল বেঞ্চৰ বিলাক আনি একেলগে দি দিব মানে সেইকাৰণে আজি সব মিক্স আহিছে তেনেকুৱা ভালে আছা তোমাৰ নামটো যে মই ইচ্ছা এতিয়া মানে মুখস্থ কৰি লৈছো পাহৰি যাও নহবা বসন্ত ঠিক আছে দিয়া এতিয়া সেইটো ঘৰতে আছা নে সেইটো ঘৰতে ঠিক আছে থাকা দিয়া ভাড়া ঘৰ পাবলৈ অলপ টানেই আছে ঠিকেই বঢ়িয়া আৰু অলপ অসুবিধা চবতে থাকিব অলপ মানে কি এটা অসুবিধা এই পানীটো অলপ মানে টাইমৰ পানী নহয় দিন পানী নাই মানে সেনেকুৱা নাথাকে সেই মাজতে একদিন অহা নাছিল পানী নাছিলে পিছত মালিকে কিনি দিছে নাই মালিকজন ভাল কাৰণে কিনি দিছে এতিয়া মই সেইদিনা যে তোমাৰ যিটো পানীৰ অসুবিধা হৈছে সেইটো কথা কওঁ মই 21 বছৰে গুৱাহাটীত আছো সেইদিনাই ময়ো পানী কিনিছো মই 8 বটল কিনিছো মানে 4 বটল 50 টকাকে কিনিলো আৰু এইবিলাক যে পাই যে 250 টকা দিব লাগে পাছত বটলটো ঘূৰাই দিলে 200 টকা দিয়ে যে এইটো তেনেকুৱা অকমান নাটনি হৈ যোৱাৰ কাৰণে কিছুমান দুষ্ট থাকে না 60 টকা কৰি দিছিলে
আৰু পাব নাই মোৰ মিছেছ আৰু বাচ্চা আছে সেইকাৰণে মই 4 বটল কিনিলো 60 টকাকে 4 বটল সেইকাৰণে একো নাই এইটো বঢ়িয়া এইদিনা চবৰে হৈছে তাকে যে আকৌ মালিকজনে কিনি দিছে ভাল মালিকৰ নাম কি মোক ফোন মাৰিছে নাই নাই বঢ়িয়া বঢ়িয়া মালিকৰ নাম কি আচ্ছা ভাল মানুহ হ'ব সি দেই কি কৰে তেখেতে শুনা এই সিঙ্গল বেঞ্চৰ এই ফাইল এটা এই 4 নম্বৰ ফাইলটো মমি 5 নম্বৰ ফাইলটো মুন্না দিয়া তাৰপিছত আমাৰ সিহঁতৰ লগত লেঠা নাই আৰু হা এতিয়া মই CIS টো কৰি আছো এতিয়া এই পাহৰি গৈছে নাই কোনো নাই না